The right of publicity is an intellectual property right to control commercial exploitation of an individual's name, image, or likeness. Not surprisingly, this right is most often associated with famous people. But what happens when a celebrity dies? Does the relevant right of publicity then cease to exist? In the 1987 Tennessee case of Elvis Presley International Memorial Foundation versus Crowell, we examine this question in the context of the king himself. Elvis Presley Enterprises, or EPE, was the registrant and assignee of all the copyrights and trademarks associated with the Elvis Presley estate, including rights of publicity. In 1980, a group of Elvis fans formed a Tennessee nonprofit named the Elvis Presley International Memorial Foundation, or IMF, to raise funds for an Elvis tribute project. IMF didn't have a license to use the Elvis name. 5 years later, EPE and the estate formed a Tennessee nonprofit corporation called the Elvis Presley Memorial Foundation, or Memorial, to raise funds for a distinct tribute project. EPE licensed use of the Elvis name to Memorial. Once Memorial was formed, the positive relationship IMF had enjoyed with EPE started to worsen. In 1985, IMF sued Memorial in trial court, seeking Memorial's dissolution and an injunction to stop Memorial from using a deceptively similar name. EPE intervened on Memorial's behalf, asserting that it had licensed use of the name to Memorial. The court granted Memorial's motion for summary judgment and dismissed the matter. IMF appealed, contending that under Tennessee law, the right of publicity wasn't descendable, and that Elvis's right of publicity landed in the public domain upon his death.